So our presentation today was on sexual harassment and sex-based misconduct in the Me Too era, focusing with the recent emphasis on Me Too in social media. We wanted to talk a little bit about kind of how that impacts employers and employees, and kind of what are the legal ramifications of sex discrimination and sexual harassment versus what the media is covering.
One of the things that was important to Erica and me as we put this presentation together was making sure that that people understand what sexual harassment is in this Me Too era. We hear a lot about sexual harassment and sexual misconduct, but what we wanted to do was make sure that employees know what I wanted to do was to make sure that employees know what kind of laws, what the laws are, how the laws protect them, and what they should and should not expect in the workplace. For instance, while we have laws that protect employees from discrimination, there's no law that requires that people just be kind to one another or be respectful. And I think that that's important for people to understand as well.
Clients are certainly more interested, based on this movement, about what their obligations are, what they should be doing if they're following the right practices, putting in place the right policies. So for employers, which is who I generally represent, I think my best advice is to make sure that you have strong policies, you have an employee handbook, that you're doing training on sexual harassment and sex discrimination and other kinds of discrimination too, of course, but making sure that your employees know what they should be reporting, how they should be reporting it, and that if they do get reports of discrimination or harassment, that they're doing thorough and fair investigations on those. Usually it's an employee complaint that they say to either their supervisor or HR that something has happened. I mean, I don't know that there's a consistent fact pattern. There are a lot of different scenarios in which sexual harassment can happen and does happen. So, but a lot of it's somebody goes to HR and says, this happened and I'm uncomfortable with it.
Employees who report sexual harassment in the workplace are often retaliated against. Up to 50% of the employees who report sexual harassment are retaliated against in one way or another, whether it's demotion, whether it's being frozen out of certain projects. But that happens when if someone reasonably believes that they've been discriminated against, the employer is not permitted to take those actions against that person. The employee should be protected from that kind of discrimination. And the reason is that we want the law to actually work for employees. The law is supposed to work for employees so that they don't have to take this kind of mistreatment and that they feel comfortable proceeding. Situations involving sexual harassment or allegations of sexual harassment or sex-based misconduct at work should always be taken seriously. The employer should investigate and investigate thoroughly and fairly. It shouldn't matter who's involved, whether it's the most senior person or the most junior person at the company, whether it's a part-time employee, a full-time employee, whether it's the employee that brings in the most income. The employer has an obligation to all of its employees, particularly the employee who has been, who's the victim here, to investigate and make sense of the allegations, find out whether they're true or false, and then take the appropriate remedial action, whether that's taking a hardline policy against misconduct. And to do that, whatever action they take, they need to do consistently, and it needs to be consistent throughout their entire organization so that people understand what the expectations are.
It's a complicated part of the law. I mean, I think having the knowledge to kind of identify the problems is important, and the general practitioner should have that. But I think if it's anything that's going to kind of go past some initial advice and investigation, if it's going to go to litigation, I think it's important that, or if they think it's a serious concern, it should probably discuss with an employment attorney.